Hello, welcome to Les Rendez-vous Partenaires with DLA Piper. Today I received Gregory Tulquois. Bonjour.
Bonjour.
You're a partner at DLA Piper based in Paris. You are in charge of industrial and commercial contracts. DLA Piper has been recently monitoring the civil code reform and created a working group with an organization of general counsel, Le Cercle Montesquieu. And you are well positioned to comment on the recent reform of the French civil code that was published recently. First of all, why a reform of the French code?
Well, as you know, the civil code dates back to 1804. It's more than 200 years old. And it really required some modernization and simplification of the language in order to make it more intelligible, in order to introduce what the French case law has been saying over the past 200 years. And that is part of contract law. And the idea also behind it was for the French governments, the successive French governments, to try and enhance the attractiveness of French contract law in order to promote it as a governing law in business transactions.
Mm-hmm. And is the reform now fully adopted?
Yes, at least regarding 300 provisions of the code. We now have visibility regarding the very latest drafting of those provisions. It was published on February 11th. It's a very comprehensive piece of work. Now, the government has announced that there will be also a reform on liability, including contract liability rules and also tort liability in the coming months. So more is to come on that.
So are these changes made significant, or is it just a brush up or a rewording of the law?
It's a little bit of both, but I would say that all changes are significant in their own way. So you basically have clauses or provisions of the code that were changed in order to introduce, to codify existing case law. So some are very clear, such as, for example, the requirement of good faith, which is not only, as currently set forth in the previous version of the code, required in respect of the performance of contracts, but also at negotiation level. Case law used to say that, and it's now introduced. And same thing, if negotiations are not able to go forward because of a lack of negotiation in good faith, then the aggrieved party is not entitled to get the benefit of what the contract would have given her had it been entered into. Another old case law that is introduced is the fact that when a party has an information that is determining, that is essential to the other party's consent, and that the other party can legitimately ignore, it has the duty of providing this information to the party that ignores it. Another example of clear central fundamental rule under contract law that was not in the code and that was introduced is the articulation of offer and acceptance, for example. What does the offer contain? What must it contain in order to be considered as an offer? Can it be withdrawn? What are the consequences? What is acceptance? When is the offer accepted? So very central, fundamental elements that are relatively stable, but that were introduced expressly in the code.
Could you mention some changes that require a particular caution on the terms of business operators?
Sure. There are quite a few that we've already spotted, and actually everything requires caution because of the way it is drafted. It could give rise to particular interpretation by the court, which might go in a slightly different direction than what it used to. An example. You have principles governing the duration of contracts. It's been stable over several years, obviously, but for example, the perpetual undertaking, a perpetual undertaking is prohibited in French law. It is considered as indefinite term agreement. That's fine, that's stabilized, it's now in the code. Something that is a little bit more delicate to and harder to get a grasp on is a termination of a contract with an indefinite term. The code says that a party can terminate a contract with an indefinite term upon giving a notice that is either the notice period that is set forth in the contract, or if there's none, a reasonable notice. Well, we all know that for several years, for many years now, case law and the commercial code also in an express provision requires that reasonable notice be given, irrespective of what the contract says. So it's going to be interesting to see how courts articulate this requirement, and it is probable that they will opt for the extensive interpretation, the most protective interpretation of the party that is terminated, i.e. look at reasonable, and if we can look at contract only if it is reasonable and if it's sufficiently long as per case law. These are concepts that were introduced but yet require caution.
And is there any innovations in the code?
Yes, and innovation that requires precisely a lot of caution. This is exactly where you have to look at in order to see the provisions that could trigger difficulties, at least we predict that they will. For example, the disappearance of the concept of cause. You used to have a requirement for a valid and lawful cause in order to be able to enter a contract. Now, this entire concept has disappeared, but it was replaced with substitutes such as aim, such as consideration, and other substitutes that are peppered throughout the provisions of the code, and it might be difficult to interpret them. Also, the consequences of the concept of cause are still there. For example, when you have a clause, and this is a new addition into the code, when you have a clause that voids the substance of an essential obligation of one of the parties, then this clause is unenforceable. It is a ratification, a validation, if you will, of the Oracle versus Forestia case law that dates back to 2010, but which was much more limited because it was only talking about limitations of liability. Now we have a full application to any clause that's in the contract. So that's interesting to follow this. Also interesting and delicate innovations to handle would be price setting mechanism. We now understand that in master agreements, both parties can agree that one of the parties will set the price unilaterally. And then the provision goes on saying, then the party will have an obligation to justify its price if it's challenged, and if there's an abuse, the other party could go to the court and ask that the court revise the price or award damages or even terminate the contract. So very new concepts and probably difficult to grasp in particular since it gives courts a very powerful role to play in contract interpretation and in contract revision, actually. And along the same lines, the idea behind this revision is also a protection of the weaker party in order to achieve so-called contractual justice. France is often worried about the fact that one of the parties can be weaker in the negotiation. And it has introduced, for this reason, in the Civil Code, a prohibition of unfair terms. We already had it in the Consumer Code, clause abusive, unfair commercial terms, unfair commercial practices, misleading practices. That was all set forth in the Consumer Code. It was even applicable in B2B context, misleading terms, a prohibition of clauses that create significant imbalance in the rights and obligations of the parties. And this is precisely what is done in the Civil Code, and another layer of protection, if you will, with a prohibition of significant imbalance in those contracts that are not negotiated. So applicable across the board. Along the very same idea, now the concept of hardship is introduced in the code. Even if you don't have a hardship clause, from the moment there is a significant change that arises that was not foreseeable at the time the contract was entered into, and that makes the performance of the contract extremely onerous for one of the parties, then this party that is aggrieved can ask for renegotiation. And there's a mechanism of giving both parties jointly, or even in case of an impasse, of a block negotiation, even one party could go to the court and ask the court to revise the contract or terminate the contract at the time and in accordance with the conditions that the court will find right. So it goes extremely far in what courts can do with a contract.
And does the reform have an international impact?
sure it does. It might have an impact in terms of inspiration. You know that, some other countries might be inspired by one of the changes or several changes that were made into the Civil Code. There might be also European harmonization, such as the European sales law principles that are in the process of being discussed. They might get some inspiration from the Civil Code reform. And also, obviously, whenever you have an international agreement that is governed by French law, then you have all this body of rules that now becomes applicable, except if and to the extent the code so allows, except if you've opted out, if you've chosen to go another way. So yes, definitely an international impact of this reform.
Thank you very much.
Thank you.